pre-trial, he's tested positive presumptively because they have to send it to a lab for confirmatory for alcohol and THC. I think they described his behavior as
Threatening.
Well, I didn't get threatening, but
I got threatening.
Okay.
And I'm going to tell you now, I'm not going to have you, and I'm not going to stand for your threatening anyone in this court at any time. That is, every part of this is an extension of us. I don't care where.
Quick reality check: a judge threatening bond revocation isn't theatrical flourish. Bond is a conditional release. If the court believes your conduct makes you a flight or safety risk, revocation is real and immediate. That line, "I will light you up like a damn Christmas tree," is the kind of rhetoric that signals the judge is done giving warnings. Audience, would you risk saying something in court that could cost you your release? Drop a yes/no in the comments.
Where you're going, I don't care what building you're in, whether you're in pretrial services, whether you're taking a drug test, it's unacceptable, and I'm revoking your bond, and you now goes with you.
if I can, Judge, I don't believe there has been actually any evidence presented to warrant a bond revocation.
She told me yesterday that there had been multiple threats.
So, all right, to circle back, there's a couple things. In speaking with pretrial, I have not received any information about threats. I've received information about cursing and rude behavior.
Yes, Judge. There was no like threat of like harm or anything like that. It was just more so attitude. He was making people in our office a little bit uncomfortable just with his demeanor and the things that he was saying, but none of it, to my knowledge, has been anything, you know, putting anyone in danger, threatening danger, anything of that sort.
This is where I
have an open criminal case. You're to be humble and contrite. And when you're not, and when you're threatening, abusive, harassing, I'm going to take care of you and I will light you up like a damn Christmas tree. Do you understand? It is unacceptable, the behavior that you have displayed here with myself, with pretrial, with the people down over there. And if you don't straighten up and fly right, I'm going to be all over you. Do you understand? One false move again. This is not supposed to be a happy time for you. And I don't know what I need to do to get your attention. But next time, I will classify you as a danger, revoke your bond, and make it so high you will have teeth falling out. Do you understand?
Sir.
Take a seat.
Thank you, Judge. Back to your point. Do you have a preference on the reset date, Judge?
So what? Tell me what he tested positive for.
It was THC and alcohol, Judge.
Okay.
This is where I will add that the court added bond conditions yesterday, so he had the magistrate.
I understand.
Okay.
He did have these magistrate orders in October that I did see that he was instructed over. It didn't have no alcohol, but it did have
October what?
October
14th, 15th.
Give me the last.
2 quick points. Presumptive positive means the field test flagged THC, but the lab confirmatory test decides the final result, so this isn't over until the lab says so. Courts can and do add testing and zero-use conditions to bond fail the test twice, and that benefit of the doubt evaporates fast. Reaction. This judge is using the testing calendar as leverage. Question for viewers: do you think random testing is fair for nonviolent charges? Why or why not?
Ask him again.
Bledsoe, B-L-E-D.
Oh no, he's still smoking weed then. I mean, if they told him not to use any kind of illegal drugs, and he tested positive right now, give me the date, please. Come up, Mr. Bledsoe. You're not off the hook yet.
This is where I will repeat my assertion that since he's out on bond, he's entitled to a hearing where the rules of evidence would apply.
What we're doing right now.
Well, then I'm going to object to hearsay to anything and everything being heard by the court.
What day was the magistrate condition for no using, please? October 20th.
I also give my spiel about THC seltzers that I could buy at Specs that have no alcohol but have THC in them.
You are not to use alcohol. You are not to use illegal drugs. I'm going to give you the benefit of the doubt, and I'm going to test you again in 2 weeks from today. If you test positive for THC again, and I don't care what it is, I don't care if it's a gummy, I don't care if it's a joint, I don't care if it's Delta 8, if it's Delta 9, if it's Delta 352, whatever it may be, you will stay with me. Do you understand?
Yes, sir.
Get whatever records you need, but if you test positive for THC again, you're on notice now. You will stay with me.
Yes, sir.
Okay.
Thank you, Judge. Have a seat back in there. Come on. But did you have a preference on the reset date, Judge?
2 weeks, whatever you want.
Oh, I'm sorry, you're right. You said
And
2
I'll
weeks.
test them back and we'll see.
Do you
But
want,
by then it'll be sufficient benefit that there's just no argument.
do you want him 2 weeks from today testing on that date?
Yeah.
Okay. Will do. Thank you, Judge.
For sure, Nate. You are Jonathan Leatherwood.
Yes, sir.
Good morning, sir. So you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed.
Okay, probable cause found. That's the pivot moment. The judge is authorizing the case to move forward. Translation for non-lawyers. The prosecution has enough to charge and keep pushing. This isn't an acquittal or conviction. It's the court saying, we've got something to answer. Quick reaction. When the judge slams bond conditions on top of a probable cause finding, it's the court locking the leash. Expect stricter oversight from here. Stay tuned. We'll break down what those next steps actually mean in plain language.
To you, sir.
Officers were dispatched to a crash in Harris County, Texas. Officers arrived and observed the defendant as the sole occupant in the driver's seat. They observed red glossy eyes, strong odor of alcohol, slurred speech, and unsteadiness. Complaining witness told officers she was sitting at a red light when the defendant rear-ended her. Complaining witness exited and walked over to defendant's car and observed an open can of beer in the cup holder. SFSTs conducted 6 out of 6 HGN, 5 out of 8 walk and turn, 3 out of 4 one-leg stand. DICs were read and defendant consented to blood sample. His license is eligible and this is his first DWI, Judge.
Open container of beer while drinking, you say?
Yes, sir.
Mr. Leatherwood, I'm going to find that there's probable cause to go forward with your case. I'm ordering you now as a condition of your bond not to consume alcohol, illegal drugs, or unprescribed controlled medication. I'm going to randomly test you. If I find that you're consuming alcohol or illegal drugs, I'm going to put you in jail. You will not get any more PR bonds. Do you understand?
Yes, sir.
Do you have a valid Texas driver license?
Yes, sir.
Do you have liability insurance in your name?
Yes, sir.
Okay, I'm now taking away your privilege to drive. You are not allowed to drive. Do you understand? I'm also making that a condition of your bond. I would hope that you understand it's elementary that you're not to have alcohol in the car while you are driving. Do you understand?
Yes, sir.
You have a lawyer. Because you have a lawyer, I will waive your appearance, but it is your responsibility to stay in touch with Mr. Strauss. If he tells me he can't get a hold of you, you pick up a new case, you endanger my county, I'm going to revoke your bond. No more PR bonds for you. Do you understand? All right. I'm going to have you come up here, swear to us that you're not going to drive. I'll get you to Victoria where we'll have you sign a reset. After that, we'll get you with Fleischer for your bond conditions, and after that, you're free to go.
Yeah, Judge, we believe, Your Honor, what was in the car was an energy drink, Judge. It was not alcohol, Your Honor.
It's just what's alleged, Judge. I mean, I don't have a photo of the
Judge, he has no priors. We would ask you, Judge, to allow him to drive while on bond.
They're alleging he's got an open container of beer in the car while he's driving. I mean, you know, if you show me that it's not, I'll take it away. But I mean, they're telling me it's an open container of beer. So do this. Is the video here? Do you have anything?
Yeah, it looks like we have some body cam, Judge.
Okay, do you want to take a look real quick to see if you see something different?
Take a look. Your
No,
Honor.
I mean, we've got time. It's
Yes, sir.
9:45,
Yes.
we've got
Take a
all
look.
day.
Don't approach.
Well, not all day, but,
Sir.
take a look real quick. I'll put this on hold if you find something different,
Yes, sir.
and once they have time, they can go out, reach to the officer, see, hey, was it really an energy drink? Was it a beer? And let's see. But if he's drinking and he's in the car and they're alleging that, no, there has to,
We'll go look at it.
yeah, sure, for sure. Mr. Leatherwood, heed this warning. You won't get another one. Do you understand? Okay, come on.
All right, Davis, come on up, page 7.
Well, hey,